In this lecture, we would like to discuss some landmark Supreme Court judgments in relation, enriching and developing the laws of insolvency, and as such, the provisions relating to Insolvency and Bankruptcy Code 2016 and the regulations of 2019 and the amendment of 2021. So, the very decisions and landmark judgments of Supreme Court evolved a particular jurisprudence of insolvency and bankruptcy. So, in that regard, we would like to discuss the first important leading case of 2021. In the leading case, Avex Singapore Private Limited versus Committee of Creditors, Educam Solution Limited, which was decided by Supreme Court in 2021. The Supreme Court held that under the Insolvency and Bankruptcy Code resolution, applicant is not entitled to withdraw or modify its resolution plan once it has been approved, even while it is pending for approval before the National Company Law Tribunal. Keeping in view the significant delays and time limitations in the court, the apex court held that in the absence of a clear provision, the adjudicating authorities could not allow such withdrawals, and also the principle laid down in this particular leading case was followed by the National Company Law Appellate Tribunal. In the leading case, Union of India versus Kapil was the one which was decided in the year 2021 to overturn the adjudicating authorities' direction to consider the resolution plan submitted by the erstwhile promoter, while another resolution plan was pending approval before the adjudicating authorities. The National Company Law Appellate Tribunal held that there was no scope for negotiation between the parties once it was approved a resolution plan. So also, in another important leading case decided by the Supreme Court in the year 2021, and that was the Vidarbha Industries Power Limited versus Axis Bank Limited of Vidarbha. The Supreme Court held that National Company Law Tribunal has the discretion to reject an application filed by a financial creditor under Section 7 of the Insolvency and Bankruptcy Code for initiation against a corporate debtor prior to the judgment if the debt and default were established. The National Company Law Tribunal admitted such applications mandatorily except where there were defects in the application. However, in Vidarbha, case, the court held that the National Company Law Tribunal may examine the overall financial health and viability of the corporate debtor and then apply its mind to examining the relevant circumstances behind such default. Further, use of the word may instead of shall, which has been used in section 9 for the operational creditor, shows that the National Company Law Tribunal's power regarding admission under section 7 of the Insolvency and Bankruptcy Code is discretionary. The Supreme Court also held that initiation of insolvency proceedings when the corporate debtor has good overall financial health amounts to penalizing the solvent companies temporarily defaulting in repayment of their financial debts. The implications of this case are very wide, but it is hoped that this judgment will be read narrowly given the peculiar facts of this particular case. And as such, we would like to discuss regarding termination of contract and the role played by the Supreme Court in deciding on this termination of contract. And in that connection, we would like to discuss the leading case of 2021, and that is Gujarat Urja Vikas Nigam Limited versus Amit Gupta. The Supreme Court analyzed the law on the validity of its effect clauses globally and concluded that if the corporate debtor is continuing to perform its obligation, in this case was power supply, then the power purchaser could not have terminated the power purchase agreement. The first 2020 amendment also extended the scope of the moratorium under section 14 of the Insolvency and Bankruptcy Code to provide that licenses, permits, concessions, and clearances issued by a government authority must not be suspended or terminated on the ground of insolvency during the moratorium period if current dues are being paid. Furthermore, the supply of goods or services critical to maintaining the corporate debtors going concern status must not be suspended if the current dues are being paid during the moratorium period. Further, Supreme Court in another important leading case in 2020, and that is Tata Consultancy Services Limited versus Vishal Kisululal Jain Resolution Professionals SK Wills Private Limited in the year 2020. Following the precedent set in Gujarat, Urja clarified that the jurisdiction of the adjudicatory authorities under the Insolvency Bankruptcy Code cannot be invoked by the corporate debtor if the termination of a contract by a third party takes place on grounds unrelated to the insolvency of the corporate debtor. The appellant had terminated the contract on the grounds that the corporate debtor had failed to perform its obligations. And this was evident from the communications between the appellant and the corporate debtor. And now we'll discuss some other important decisions in regards to jurisdiction of National Company Law Tribunal with respect to proceedings against personal guarantors. So, the Supreme Court and the National Company Law Appellate Tribunal have provided much needed clarity with respect to the jurisdiction of National Company Law Tribunal for proceedings against personal guarantors. And as it was in the leading case, in 2021, the Madras High Court also the National Company Law Tribunal in Mumbai had laid down that insolvency proceedings against personal guarantors to corporate debtors which are not undergoing can be initiated only before debt recovery tribunals. And in the same way, in 2021, the National Company Law Tribunal of Delhi had held that in cases where the application in relation to the corporate debtor or initiation pending at the National Company Law Tribunal not a prerequisite for the maintainability of an application for initiating insolvency proceedings against personal guarantors before National Company Law Tribunal. So also, we would like to discuss another important leading case of 2022, and that is State Bank of India versus Mahendra Kumar Jajodia, where the National Company Law Appellate Tribunal held that an application filed for the initiation of insolvency proceedings against personal guarantors before the National Company Law Tribunal cannot be rejected solely because no liquidation is pending before the National Company Law Tribunal. This decision of the National Company Law Appellate Tribunal was upheld by the Apex Court or the Supreme Court. And also in 2022, in the leading case, Mahendra Kumar Jajodia versus State Bank of India, Stressed Assets Management Branch, and also further in another important leading case in the same year in 2022 in Gurmeet Sodhi versus Union of India, which is a plea challenging the constitutional validity of provisions relating to insolvency of individual, the Supreme Court issued a notice in the matter. Therefore, the law on personal insolvency is evolving and much is contingent on the outcome of this case. And so also, we would like to discuss some other important leading cases as such. The Consolidated Construction Consortium versus Etro Energy Solutions Private Limited, and which was also decided in 2022 by the Supreme Court, where it was held that any advance payment given to the provider of goods or services would come under the definition of operational debt under the Insolvency and Bankruptcy Code of 2016. As operational debt includes a debt arising from a contract in relation to the supply of goods or services from the corporate debtor. It further elaborated its reasoning by stating that Section 5, subsection 21 of the Insolvency and Bankruptcy Code Act of 2016 defines operational debt as a claim in respect of the provisions of goods or services. The judgment clearly mentions that the claim must bear some nexus with the provision of goods or services without specifying who is to be supplier or receiver. So this judgment has created new jurisprudence in the Insolvency and Bankruptcy Code by including the advance money given for goods or services in the definition of operational debt. So, another important leading case that delivered by the Supreme Court in the same year in 2021, where in this particular case, New Okhla Industrial Development Authority versus Anand Sonbhadra in the year 2022, Supreme Court has held that a lease is considered a financial lease if the lease term is for the major part of the economic life of the underlying asset. The Supreme Court stated that the economic life of land underlying asset is not limited, and as the lease deed was for 90 years, this lease deed cannot be considered a financial lease. Accordingly, such a lessor would be an operational creditor and not a financial creditor. This issue was required to be resolved as by the New Oakland Industrial Development Authority, a government land owing authority, was claiming the status of financial creditor in the solvency of a number of real estate companies. So, now we'll discuss some other important landmark judgment in applicability of the limitation of law on the proceedings under Insolvency and Bankruptcy Code, where the Supreme Court in particular in the leading case in 2021, and that is Dena Bank. Now it is known as Bank of Baroda versus C. Shivkumar Reddy and another. While referring to its multiple earlier judgments, the Supreme Court, with respect to the applicability of limitation law on Insolvency and Bankruptcy Code proceedings, held that an application under the Insolvency and Bankruptcy Code would not be barred by limitation on the ground that it had been filed beyond a period of 3 years from the date of declaration of the loan account of the corporate debtor as non-performing asset if there was an acknowledgement of the debt by the corporate debtor before expiry of the period of limitation of 3 years, in which case the period of limitation would get extended by a further period of 3 years. So, some other important leading case relating to insolvency and bankruptcy, as Supreme Court reiterated that the principle of non-interference by the National Company Law Tribunal in the commercial wisdom, and it was decided by the apex court in 2022 in the leading case Balal RCK versus MS Siva Industries and Holdings Limited and others were stating that members permit settlement and withdrawal and of National Company Law Appellate Tribunal cannot sit in an appeal over the commercial wisdom. This may settle the debate with respect to the approval of resolution plans in which the creditors take large haircuts. So, the National Company Law Tribunal in Videocon Industries matter had raised concern with regard to the approval of the resolution plan in which the creditors were taking a 96% haircut. So the Supreme Court ruling in Shiba Industries provided much needed clarification regarding the powers. So also would like to discuss another important leading case decided in 2021 by the National Company Law Appellate Tribunal is the Bank of Maharashtra versus Videocon Industries, where it reiterated the principle of non-justifiability of the commercial wisdom and held that the National Company Law Tribunal and the National Company Law Appellate Tribunal can send back the resolution plan to the COC for reconsideration, even in cases where the creditors are taking large haircut. So, in that regard, as such amendments were brought into the insolvency bankruptcy court, but now we will discuss an important leading case of 2019 as relates to Jet Airways, which was an Indian company with its center of main interest in India. The insolvency and bankruptcy court proceedings in India were the main insolvency proceedings, and the DOS proceedings were non-main proceedings as it was held by the National Company Law Appellate Tribunal. So in the case of Videocon Industries, The adjudicating authorities in India permitted the inclusion of the foreign assets held through other companies to be included in the resolution process. Further, the adjudicating authorities also declared that the moratorium under Section 14 of the Insolvency and Bankruptcy Code is applicable to those foreign assets. However, this was held in the same year in 2019, and the very case was relating to Videocon Industries, where it was held that, however, in the absence of a clear framework, these matters have to be dealt with on a case by case basis. So, these are the important landmark judgment delivered by the apex court or Supreme Court of India and also by the National Company Law Tribunal and the National Company Law Appellate Tribunal in relating to insolvency and bankruptcy, which is particularly relating to corporate bankruptcy or insolvency. So now we want to conclude our lecture on law of insolvency. Insofar as any legislation can have a transformative effect, the Insolvency Bankruptcy Code has achieved that objective. Unlike its predecessors, the Insolvency and Bankruptcy Code has been adopted well by the system. So, the government has been proactive in ensuring that problems are dealt with, and the courts have also, with the exception of some occasional stray orders, refrained from overturning the decisions of the COC for international leaders and stakeholders, lenders and stakeholders. This is good news, as it also points to the robustness of the IBC to meet evolving challenges. The COVID 19 pandemic and its resultant economic stress on certain businesses was likely to result in a greater number of insolvency and bankruptcy court proceedings. The government will do well to fill the vacancies in the National Company Law Tribunal in time to enable the judicial system to rise to the occasion. So, in this lecture, we have completed the entire laws relating to insolvency and how during the British period the laws in relating to insolvency developed, and in particularly it took the very form of Residency Towns Insolvency Act 1909 and the Provincial Towns Insolvency Act 1920, and subsequently it was amended in the year 1978, and regarding that we have discussed in detail about the old acts which are specifically was applicable to the presidency towns of Mumbai, Chennai and Kolkata, and also some small provincial towns And finally, we have discussed in detail the Insolvency and Bankruptcy Code of 2016 and how it was relates to the Indian Companies Act of 1956 and how the Companies Act was drastically modified and changed in the year 2002 and 2013, and also the relevant regulations in regards to Insolvency and Bankruptcy Code of 2019 and subsequently the amendment to Insolvency and Bankruptcy Code in 2021. So, also we have discussed those landmark trend setting judgments of the Supreme Court and also the National Company Law Appellate Tribunal in the very development and evolution of insolvency and bankruptcy laws in India.